Hello, I'm Adam Harrison. Today's video segment is going to talk about subsurface excavation and differing site conditions. Most contractors are aware of contract clauses that require visitation to the project site to determine the nature and characteristics of existing conditions. Often, these clauses attempt to shift risk to the contractor under the premise that the owner does not warrant the condition of the site and the contractor takes the site as is at the time the contract is executed. But what happens when the conditions are subsurface and not readily ascertainable from a visual inspection? The contract documents, soils reports, and visual inspections can be instructive, but underground construction remains an uncertain gamble even with today's advancements in technology. Controversies such as soil bearing capacity, rock elevation and quantity, groundwater elevation, unsuitable fill, buried man-made obstructions, and other unanticipated conditions can greatly affect the profitability of jobs, even the continued solvency for the subcontractor. These disputes often spill into the courts, and when they do, the written contract is the most important piece of evidence. Historically, the courts would look to the language of the contract and strictly construe that language. If the contractor agreed to perform a specific scope of work, the contractor was bound to perform that scope of work no matter what the cost. This would lead contractors to include large contingencies in their bid to account for unforeseen conditions. As contracts began to evolve during the turn of the century, extra work clauses would be invoked when unforeseen conditions were encountered, with the argument that the changed conditions constituted a change to the contract justifying additional compensation. In the absence of such a clause, contractors would argue theories such as defective design, owner misrepresentations of conditions, and the like. Today, every standard form commercial construction contract and most proprietary construction contracts contain formal differing site condition clauses that allocate the risk of unforeseen or unknown conditions to the project owner. At the same time, this helps alleviate and reduce contractor contingencies in their bids. There are two types of differing site conditions, and these are usually referred to as Type 1 and Type 2 differing site conditions. Type 1 conditions are subsurface or latent physical conditions which differ materially from those indicated in the contract. For a contractor to receive additional compensation under this type of condition, the contract must contain a representation of the condition in the contract documents, and the condition encountered must differ materially from what was represented. A compensable Type 1 condition is usually one that is reasonably unforeseeable on the basis of all of the information available to the contractor at the time of bidding. A Type 2 differing site condition is defined as unknown physical conditions of an unusual nature which differ materially from those ordinarily encountered and generally recognized as inhering in work of the character provided for in the contract. An example of a Type 2 condition is the encountering of a subsurface structure in an area which appeared to only contain soil. Regardless of whether it's a Type 1 condition or a Type 2 condition, it is imperative that the contractor provide the owner with written notice so that the owner has an opportunity to investigate the condition before it's disturbed. The owner is then charged with the obligation to investigate the condition so it can act accordingly with an adjustment to the contract. So how does this information affect you? The prudent contractor will visit the project site to develop a situational awareness as to all of the conditions and all of the circumstances that might impact the project and impact its bid. In addition, the prudent contractor will look at all of the contract documents, will look at any documents incorporated by reference, including the prime contract, soils reports, any other documents that are attached as exhibits to the contract documents to understand every representation that is being made by the owner with respect to the project site. And finally, the prudent contractor will look at the contract that it is about to execute to make sure it contains a formal differing site condition clause in the event it does encounter differing site conditions. As you might expect, the facts and circumstances differ for every differing site condition claim. Competent legal counsel should be contacted with any questions.